Do you think life is simpler as time evolves? For some, it can be more complicated when facing issues about health, estate plans, probate, long-term care, and more. That's why Attorney-CPA Joe Cordell hosts ElderTalk with TuckerAllen, providing intelligent answers for those thinking about their future. Here's Attorney-CPA Joe Cordell.
Welcome to another episode of ElderTalk. This week we want to return, as we must periodically. After all, this show is sponsored by TuckerAllen. So we must occasionally come back and talk about estate planning issues. And in fairness, Jill, when we look at our audience, an audience of people who, for the most part, in the last third of their lives,
right,
it's an important topic. And so I think that it behooves us, as we do periodically, to circle back and talk about it. And fortunately, we have access to some great attorneys with great information. And this is one of those weeks when we're going to talk a little bit about your estate planning. So toward that end, we have with us this week Missy Shands Manning. Many of you know her. She's an attorney with TuckerAllen. She's been on, of course, before. And she has a wonderful ability to talk about complicated subjects potentially in a way that people understand. So, Jill, you want to launch us in this conversation?
So, Missy, I want to talk about the biggest mistakes people make with estate planning. And what comes to mind? Not creating an estate plan at all.
That has to be the number one problem.
That's got to be way up there on that list.
How do you know with TuckerAllen, though, when that's happening? Are these people that come in after someone has passed away even?
Yes.
And that's when you first find out there's no plan, because by definition, they didn't come in before.
Correct.
And so we're talking crisis mode here?
Oh, yes.
Panic, I
Yes.
can imagine.
Well, describe the process in real simple terms so people get it.
Sure. So when someone passes away, they leave behind a family member or a friend who usually goes through their stuff in search of a will or a trust, and they don't come up with anything. Then they get this panic look on their face, and they call up an attorney, and they tell us, well, I can't find a will, or I can't find a trust, and I don't really know what's going on, but we got to get her stuff figured out or his stuff figured out. And so we set up a client meeting with them, and we come in and we sit down and we talk about the intestate probate process, which I know sounds really scary, and it is kind of scary. It's very complicated, and it takes a very long time.
So intestate, just for our listeners' benefit, that means you die without a will.
Correct.
Or a trust.
Mm-hmm.
And we keep saying the word will. An alternative to a will, or often a supplement, but really an alternative to a will, is to do a trust or something where things don't go into the estate.
Correct. So if they don't have a will or a trust, then we're going to have to go with the government's plan on where that person's assets are going to be divided out to.
But how do we know that a will doesn't really exist because they haven't found it in their loved one's home? Couldn't that will be kept at some attorney's office or maybe a safety deposit box? And how would you go about finding it? It seems like a needle in a haystack to me. But
oftentimes it is, Jill. So if they can't find it in the first brush through, we usually talk to them about various other options of where it could be. So if we know that they had an attorney, we usually reach out to that attorney's office and ask them, do you have anything on file? We usually go back through bank account statements and see if they have a safe deposit box that they were paying for. But if all of these options come up negative, then we have to go.
You have to assume there is no will.
Yep.
But that's interesting because sometimes people might very secretly create a will, but that's the exception of the rule, I suspect. I suspect most people, when they're older, they tell their kids, I have a will. They may not tell their kids what's in it, mm-hmm. or they may tell them something that's not true that's in it.
Yeah.
But I would think if the kids are saying, as they probably often do, yeah, I think mom or dad had a will, then you have to do your search, right?
Yep. So it can get pretty nitty-gritty, and a will is only valid for 1 year after the person passes away. So if it's not found within that 1 year, that's it. They could pull it out a year and a day later, and it's no longer valid anymore.
So then it's treated as if they died without a will.
Correct.
Right.
Now, I don't want to be suspicious, but sometimes lawyers by nature are. I would be concerned that it might be in the interest of some family member to let that year go by if they thought the intestate rules were going to give them a larger share. You don't want to think cynically like that.
But it happens, sure. And then they filed that will, on the eve of its 1 year anniversary.
Yeah. So probably there's a lesson here about how wills should be kept and who they should be disclosed to. So so we identified a problem. So what would be your solution to the piece about there may be a will or a trust and nobody can find it? Give our audience a recommendation. How do you fix that?
All right, so the easiest thing to do is leave your will or your trust or whatever your estate planning documents are in a place where people can find it. So don't put it in your safe unless someone has a combination to the safe. Don't put it in your safe deposit box unless someone has authority to get into it. So tell someone where it is and tell them how to get it.
Because isn't it true if you have it at the bank, unless you have that key, the bank can't give you another key, correct?
No, so it can get very sticky with safe deposit boxes. We've had lots of times where clients have to go to court to get a court order to open up a safe deposit box in order to get their estate planning documents.
Wait, now this is the estate planning documents of the parent, we'll say.
Yes.
So the parent could have gotten it unless they're incompetent. But what happens is something happens to the parent, they either die or have a stroke or something, then it's the family that's trying to get access and they can't.
Exactly.
Often. So in fairness, some people, what they've done is, I've heard the phrase used, poor man's will, where they might have various beneficiaries on certain accounts. So it is a little messy where if there is no will or if there's a lost will, there may be some accounts that will go directly to particular people and bypass probate. So kind of explain that.
And you're talking about POD, payable upon death?
It could be various things.
Yeah, so the technical name is non-probate transfers because we don't have to go through probate in order to get that money. So on your bank account, you could put a transfer on death or a payable on death. Same thing with life insurance and your 401k. You usually put down a beneficiary on those. So those will avoid probate, and you don't have to worry about getting a will or a trust in place. But the downside to that method is you're banking that your beneficiary is still going to be around and able to go and get that money.
Yeah, not to mention various other problems that you can't choose to distribute the money in a way that you would like typically. You can't have the controls that you might want to have. You might want to have some protective language there for the recipient. You can't do any of that. So it's really a very blunt instrument, and I agree that it's better than nothing is what I would say to somebody who had no alternative. But it's not something that anybody wants as Plan A. Plan A should be to take the opportunity while they can to create a wonderful plan that reflects what's important to them.
I completely agree.
And what's the problem about limiting estate planning documents to just a will? What problems can arise? And I'm assuming you're going to recommend a trust, and will leave you open to legal challenges. Is that correct?
So the biggest problem with just a will is the most common estate planning myth. People believe that if they create a will that they're going to avoid probate, and that's not true. So just because you wrote it in your will doesn't mean that we're going to skip it out and just immediately start paying those assets to your beneficiaries. Think of your will as an instruction sheet to the probate court. The judge is going to say, this is where you want your asset to go, and it'll follow along that route, but we still have to go through the whole probate process to get there.
Okay, That's a good way of thinking about it, an instruction sheet for probate court.
Yeah, and you might think of probate as existing primarily to receive wills and to assure that they're accurate, to assure that creditors get paid first, and assure that they're distributed to the right people. So it's kind of like probate is created primarily to receive these wills.
And I think we touched upon before about failing to plan for incapacity. So say something happens, you have a stroke or you start showing signs of Alzheimer's, and your loved ones have no idea where you're keeping these legal documents, your will, your trust, whatever the case may be.
We're trying to identify things that you have told us, Missy, constitute common major errors. And this one has to be near the top of the list. And for people who are most concerned about the quality of the balance of their life, this is a huge mistake to not have something in place in the event that you become incompetent.
That is completely accurate. So a lot of times people come in with a will, but they haven't thought about doing a durable power of attorney or a healthcare power of attorney in case they become incapacitated, which is super important right now with COVID. You never know what's going to happen out there. If you're in the hospital, someone's going to have to pay your bills so you have a house to come home to. Someone's going to have to make healthcare decisions for you when you can't make them for yourself.
Yeah, I mean, there's so many aspects of our life that we don't realize requires our voice or our signature, some way in which only we can manage it.
Right.
Like now, so much is protected with privacy laws. Obviously, all your healthcare information, believe it or not, your loved ones actually cannot walk in and say, give me a report on Dad's condition, unless there's some document that authorizes a physician to do that.
Right.
Or unless there's a court order, heaven forbid, that you have to go to court. And incidentally, that's a probate proceeding too.
Yes.
So we mentioned that probate is primarily for wills, but I chose my words carefully because it does a few other things. Incidentally, none of them, while it's better than nothing, none of us want to end up in probate to solve problems, whatever the problem is. And one of them is when your loved one becomes incompetent. How often does it happen where you have somebody who didn't have a durable power of attorney and something's happened, and what is it, usually a child of that person, an adult child who calls?
Oftentimes, we get guardian conservatorship cases every day. That's the court process of getting someone appointed to make financial and personal decisions for you when you don't have a durable power of attorney in place.
And I want to walk through that because people have heard those phrases, but I want them to understand it. And remember, our purpose here is not to create fearful scenarios for you to worry about. But our purpose here is, though, to communicate that these are real-world problems, and this all seems academic until it happens to you.
And it's something that can be avoided.
And it's something that can be avoided, of course, and that's the most important thing, that it can be avoided. But I know that many people listen to these scenarios and they think, well, that's kind of a boring topic, and implicitly they're saying, this isn't going to happen to me. But when it does happen to you, and these are not improbable scenarios, it's not as if the you is 1 in 100,000. I mean, this happens every day, and it happens even among your friends, I bet, if you ask around.
Right.
So I want you to describe what is the alternative if somebody's not taken time to create a good, durable power of attorney in the event that they become incompetent so somebody can kind of take care of the business of their lives.
It's quite a doozy, Mr. Cordell. So the process begins when a child or some other relative comes in and sits down and talks with us, and we ask them to make certain that there's no durable power of attorney because that's by far the easiest thing to use. And if there's no planning, then we talk about a petition for guardian conservatorship. So we have to fill out a court order requesting that someone be appointed as guardian or conservator for the person who is incompetent. We have to get a doctor's investigation into the person's capacity and get the doctor to testify that that person lacks capacity and can't take care of themselves anymore. Then we have a court-appointed attorney assigned to that person.
A guardian.
A court-appointed attorney represents the incapacitated person to make certain we're not taking advantage of them.
Which are all checks and balances that we would want. I mean, if you're going to have to go through this process, you want to be sure it's not abused.
Absolutely. But you've also got to pay that person's bill, too.
So there's a lot of money coming out of somebody's pocket going to court and getting authority to a family member to be able to take care of these things.
Yes.
And that money is paid from what source?
So initially, the person who's seeking the guardian conservatorship has to pay that money because we can't get access to the incapacitated person's money. Then we apply to the court to get reimbursed from their funds, but there's no guarantee of that.
Just listening to this process, it's really exhausting. I mean, I imagine you have a lot of headaches dealing with some of these situations.
And it doesn't
Absolutely.
stop there, though.
No.
Meaning that they have to also submit their reports and et cetera. Talk a little bit about that.
So every dollar that goes in and out of that incapacitated person's virtual wallet, if you will, has to be reported back to the probate court. And the probate court has to approve each and every expenditure and income. So at the end of every year, they get a thick stack of papers and receipts, and the judge goes through it and authorizes some things and potentially not others.
And this sort of oversight is an ongoing thing. So if somebody were to have a stroke and be in this condition for years, this is going to be what life is like for whichever likely child of that person is appointed by the court. Now, a thing worth mentioning is it doesn't have to be a family member. The court could look at the kids and say, I don't think any of you can be trusted with this position, so I'm going to choose a stranger.
That is
And
true.
how do they find that stranger?
Well, the court they can choose a lawyer to appoint as a guardian who would have responsibility on an ongoing basis. This could be somebody that's appointed or has a reputation with the court already. But the bottom line is it's a stranger.
So it's not somebody that the family knew, a lawyer that the family knew before this.
The family could propose that person as an alternative, sure. So the court is wanting to handle this the most efficient way it can. So if they think the kids can't do it or they think the kids are fighting a lot, that's another big problem. It may be that you have wonderful kids, but there's fundamental disagreement. There are two aspects to this, and I'll let you talk about that. There's kind of a guardian for the money and a sort of a healthcare guardian, and those might be two different people. Is that right?
That can be. Usually we try and make them the same person because it makes things easier and so there won't be any potential disagreement. But the guardian for the person's health and well-being is literally called the guardian. And the guardian for the money is called a conservator.
The picture we're describing here is not some improbable scenario. I just want to repeat that so that people get it, because all too often people assume that they're fine and that they're not going to have any sort of period where they're incompetent. And hopefully none of our family, each of us thinks, will. And that's possible that they won't. But we all know people for whom this has been what they've had to deal with. So the importance of having this document, it's such an easy fix to what's potentially a very complicated, expensive thing. I wonder how much money in total is going to come out of your listener, out of your account to pay for these various costs. First, typically, while you said, Missy, that the judge can approve or disapprove the costs, so it's always possible that the family member could get nailed with some expense to pay personally. But assuming it's all okay, it's still a lot of money, and it's coming out of the bank accounts or the reserves of the older person who's had this event. And so when you throw in all the professionals that are feeding off of this account, that's a harsh characterization. But anyway, that are profiting, I don't want to say profiteering, but even legitimately, there are a lot of professionals that are being paid fees through this whole process. And as we said a few moments ago, it doesn't stop. It doesn't stop until, of course, you pass away or become competent again. But the court doesn't come in, appoint somebody, and then go away. It's a scenario where the court stays involved. And again, we can be devil's advocate and justify that, right? Because, we all know that there's too much potential for mischief for somebody to get that authority and go run down the road with no oversight. But still, why would we choose that process when it's so easily prevented?
Is it because people think, I'm going to live forever and nothing ever, bad is going to happen?
Sometimes it's concern about giving power over to someone. They don't feel the trust. Maybe they don't think that their child is ready for that. They're not sure who to trust with that.
Yeah. It's kind of like this is a complicated decision. I've heard clients say, well, my youngest child is the one who really probably has the best judgment, and my older child's a little irresponsible, maybe a ne'er-do-well. They don't use that word. And then they say, but it will offend my oldest child if I appoint. So can I give them equal authority? And you want to discourage that. Talk a little bit about how people make this decision and some of the solutions for the people who say, well, I don't want to give them that authority today. I only want them to have it if I really do have an event occur.
The key thing to remember is that this is not an honor. This is a burden. If it's going to hurt the oldest one's feelings, that's okay. It's not an honor. Passing it down to the most suited child is the best decision because it's the most important thing that you're going to be deciding. Another way to potentially plan for potential conflict in the future, or right now, is to have a springing power of attorney, which I know sounds kind of silly, like a spring, but it isn't effective until you become incapacitated as determined by one or two doctors, and only at that point does that person have power over you.
Yeah, so it's important for our listeners to understand that, because you can just have a power in which you trust this person. Let's assume that it's not a difficult decision. There's an obvious choice for this person. Maybe it's your oldest daughter, for example. And maybe she's also the only one that's in town. The others are the out-of-town kids. So
it would just make more sense.
Yeah. And so I think, I want you to tell me what you estimate this to be. As I recall, most people, when I was doing this planning, which I'm not currently doing, but when I was doing this planning directly for clients, I think a majority just went with it being in effect from day one without the springing. And I'm curious, has that changed? Is that what most people do today?
Absolutely. In fact, that's what we highly recommend nowadays, just because so many banks are scared of springing powers of attorney that they don't want to take that liability on to say this person is a real doctor and did certify them as incapacitated. So just if they trust the person and they can make it work, then we try and do the immediate power of attorney for almost everyone, unless they have that situation where they just don't trust who they're naming.
Yeah, and I want that to make sense. So that people are clear, a bank isn't, or any other financial institution or hospital, they have to worry that this triggering event has actually occurred. So now you can have a means in which that is certified and with a notary. So it's not as if it's this real foggy thing, but it is true, as you said, Missy, that a lot of financial institutions especially become nervous for fear that the person isn't truly incompetent, that maybe these signatures aren't original, and whether these are the right doctors. So it can cause delay. And the wonderful thing about this document is for it to be able to work immediately. Decisions are made immediately about your health care, about paying for hospital bills, about airlifts, all these important decisions that may regard a significant amount of money, and they have to be made in short order, not a month after you have a stroke, for example, but hours. And so in order to have that, it's better to have fewer hurdles. The fewer hurdles you can have, the better. And so for that reason, describe the way that these would typically work.
So a regular immediate power of attorney, you would sign in it. As soon as it's signed, the person who you nominated as your agent has the power to conduct business on your behalf while you have capacity and you give them consent. So let's say you have knee surgery and you're not up for standing in line and renewing your plates at the DMV. You can send your agent over there to take care of that for you. You still have capacity and you told them to go and do it for you, so it's perfectly valid and they can take care of it. Then, when you become incapacitated for a stroke or whatever reason it might be, that person doesn't need to wait for your consent anymore because you can no longer legally give that consent because you're incapacitated.
Right.
So then they'll just start making decisions based on what's in your best interest.
What about limiting your estate planning to just a living trust? What kind of issues can come up there with that?
So we always want to pair a trust with a pour-over will. Pour as in like you're pouring something out of a glass. So a pour-over will is in place in case you forget to accidentally put something into your trust. A big one is cars. People go out and they buy their shiny new cars and they're so excited, they forget to put their trust down as transfer on death at the DMV.
So is that what we mean by not funding your living trust?
Yes. So when that happens, your pour-over will catch that asset. It'll be a quicker, cheaper probate process, and then the car goes into your trust, and your trustee can decide to sell the car or distribute it to one of your beneficiaries.
Yeah. And a lot of people think that some people know what a trust is, which is not anything real complicated. It's just this container where you title your assets and you place somebody as a trustee to be in charge of it, which can be you for a while, you, the listener, for example. You can be in charge of your own trust, so life goes on as it otherwise would. And then if something happens to you, like in this scenario too we just described, the trustee will often be the person who holds the durable power of attorney. So if you have your assets inside the trust, then the trustee can manage them, even if you become incompetent. If you've named like a successor trustee, and that's that word. Successor just means that you have a list of people that come after you when you can't manage your own trust. And remember, managing a trust just means doing what you're already doing with your stuff. It's just that your stuff is listed as owned by a trust, and you're listed as a trustee. So it's a very convenient way to plan your estate. It's good for you while you're alive, and especially when you become incompetent. But it's also good for when you pass away, because then you name a successor trustee, and guess what? I mean, at the risk of sounding morbid, literally within hours of death, if they were so inclined, and you would hope they wouldn't be, but your loved ones can be distributing your stuff.
Yeah.
And, I mean, it could be that quick. In contrast to this scenario you mentioned a while ago, Missy, where you're in probate court for 6 months to a year, money's running through your account, sands going through the hourglass in terms of passage of time and notices that have to be given to creditors, et cetera. So trusts are such a marvelous, convenient, efficient device that it's a shame that they're not more commonly used.
And too, I think, and I can't emphasize this enough, using an experienced estate planning attorney, I mean, it's crucial. I know one time after my mother passed away, I had an issue come up and I had to go see an attorney that was recommended. And apparently this gentleman wasn't well versed with this particular issue. And he said, well, I'm going to have to do some research, and my fee is $300 an hour, and this could be 20 hours of research. And I was like, immediately I nixed that, because I thought, if you're really an experienced estate planning attorney, you should know this. So it's important that you do your homework.
Absolutely. So at TuckerAllen, we limit our practice to estate planning and elder law. So this is all we do. We don't do car accidents. We don't do medical malpractice or anything like that. This is what we do. This is our bread and butter. And when you come in and ask us a question, most of the time we got an answer right there, unless it's really off the wall, and then we should be able to tell you pretty quickly.
Right. So it's your area of expertise. And also, want to point out, many people want to go the cheap way and do an online will. And that can be a disaster.
Oh my goodness. I have some fun stories for you about that. So we recently had someone I knew passed away who had done like a LegalZoom sort of will. And he had listed all of his assets and where they were going to go. And he took it to the bank and he got it notarized and witnessed at the bank. The will was valid. However, LegalZoom is not an attorney.
Sure.
So, they didn't include a bunch of things that are really important to include in a will. It's called a attestation clause, which I know sounds very scary, but basically it's just a recitation saying that this person was the person who executed the will, and they did it in front of these two witnesses, and they followed all the legal procedures. It's super easy. It's super important to put in the will, and they didn't do that in this LegalZoom will. So they had to find these witnesses from 15 years ago based on their signatures. We didn't even have their actual names, just a scribble signature.
Oh my
in order
goodness.
to prove that they were actually there when he signed the document and he was who he said he was. They wasted thousands of dollars trying to hunt down these two people to prove this will.
So, and this happened, this is LegalZoom will was 15 years before, and that's why they had to find these two individuals. So what would have happened if they wouldn't have?
Then the will wouldn't have been able to be proved as valid.
And once again, ending up in probate.
Yep. So if he had gone to a real attorney, he would have gotten a will that included that very simple statement that all of the procedures were observed, and he would have been fine and in and out of court. He still would have had to go through probate, but it was much easier.
It sounds self-serving whenever a lawyer says it's really crazy to not, go get a will or use a lawyer for this or that. But this is one of those topics that I incur that risk. The fact is, it's really foolish, and I'm impatient with, I can even say family members, and I don't have many, but I'm thinking of one, who was wanting to avoid the cost of doing, in this case, just a will. This person was just going to do a will, not a trust. And to save money, had gotten a form or something. And I was really impatient with that because I mean, there aren't many things in life where you feel like you have to go to lawyers. Maybe there are more today than there were 100 years ago, but the point is you can do a lot of things yourself. And it makes sense to try to cut expenses to the bone in many areas, but this is not one of them.
No.
I mean, how much are we talking about? In this case, I can tell you that I'm referring to, we're talking about less than $500 probably. And because this person didn't have much in the way of assets, but had assets. Let me emphasize that. Had assets, but not much. And here's the bottom line. In any case, it's 100% of what they had. So in an effort to avoid $500 in this case, and I'd make the same argument if it were $2,000, and I'm not being cavalier about $2,000, but I am saying the magnitude of everything you've done in your life, whatever you have, however much it is, it's all you have.
Right.
And to think that it's more important to shave off even a couple $1,000s on this one-time event that's going to determine to some extent the rest of your life, unless you happen to never have any period of incompetency, but in any case will determine the fate of whatever you've accumulated in this life. I'm just impatient with people who are so tight-fisted that those are times that they are trying to save money to the extent that they compromise on those issues.
And it's just too important. And you think about, okay, you have an injury. You're not going to do it yourself. You're going to go to an expert, that expert being a doctor. So with your legal matters, why wouldn't you go to an expert, meaning a lawyer, and one that specializes in this type of law?
Yeah, and we could use the same example that you described. We could use it with a doctor, and it could be that we all know this. Some of you listening may yourselves potentially, or maybe a family member. They go to a general practitioner because maybe there's no deductible or it's within their plan, and whatever the reason may be. Maybe it's just convenient, and they don't want to bother going to a specialist, or they don't want to bother seeking out somebody that they know is a better doctor but may not be local. So you can choose your scenarios, but there are some things in life where trying to save money or avoid inconvenience is just too expensive.
Right.
Expensive in other ways. And healthcare and the sort of issues that we're talking about here, which I would call life care, it's not just legal, it's life care. I don't think those are times when people should be shopping for a form or even getting, the least expensive lawyer they can find. And I know that sounds self-serving because I'm a lawyer, but I can promise you that I would have the same view if I weren't a lawyer.
Right.
Because I think it applies to a lot of things in life.
And, it goes back to the saying, you get what you pay for. Now, Missy, what would you have to say about the pitfalls of naming the wrong successor, the wrong trustee? Huge problems can arise out of that.
Yeah, so if we go back to your previous scenario where you had the two kids and the oldest one would have been upset, so you decided to name the oldest kid, even though it was probably not the best choice. Mm-hmm. Well, come around after you pass away or you become incapacitated, those two kids are going to be majorly at odds. That oldest child is going to have to step up and make good decisions about what's best for you and not just what's best for him. If you name the wrong person, you could be looking at a loss of a lot of money and a loss of your family relationships, too.
Yeah.
Oh, I bet.
That sort of thing it can end up being far more trouble and even more conflict than doing the right thing. Let's talk a little bit more, though, about some of the solutions, Missy, that people can craft. I remember some clients who would have, say, 3 children. I'm choosing an odd number, so that, if you have a vote, give the advantages and disadvantages of putting on, say they have 3 kids and they put all 3 on to avoid disagreement.
So if you name all 3 as your co-successor trustees, as an advantage, no one gets left out. They all make decisions together. There are a lot of really big disadvantages to that, though. So when there are 3 heads, it's like you can only have one captain on a ship. So it leads to duplication where maybe two of the kids are going to be paying your bills and they get paid twice. Or one child thinks the other child is paying the bills and it never gets paid. What if they can't make a decision on what they're going to do for your health care?
And what if they can't all be located and a decision needs to be made urgently? Are they all living within a mile of the hospital? I doubt it. Or the nursing home or whatever it might be.
So making a decision by consensus is no way to proceed through a trust administration.
It's generally best to have a single individual, but again, there are exceptions, and it's better to have one with 3 kids named. I think you agree with this, Missy. It's better to have one with 3 kids named than to not have one. But still, it probably is best to give that responsibility to one person. In nothing else, you could have a tiebreaker person, but still it means delay. So it's in that case, it may avoid having a being frozen in terms of a decision, but it doesn't prevent being delayed and the efficiency of being able to address things as they come up without having to locate people in different parts of the country, et cetera.
Yeah, and I know of a case personally. A friend of mine, she and her sister were both trustees, and her sister unfortunately had a drug problem, so she was dipping into the account. And my friend wasn't monitoring the account. So all of this money is disappearing, and they still hadn't distributed the money to all of the heirs. So it created a huge mess.
Yeah. And sometimes people, they don't have good candidates. They end up with candidates like you described.
Yeah.
So let's talk a little bit about kind of the corporate trustee option.
Sure. So if you don't have a good fit, a really good trustworthy person to name as your successor trustee, or even on your durable power of attorney, there are corporations that will do that for you, and they will do it in a quick and efficient manner. They will charge a fee for their services, somewhere between 1% to 3% of the value of the trust each year. But when you compare that to potentially having a trustee who has problems with drug addiction, it's well worth the money, and hopefully your trust would be accumulating interest anyways, so you're not really losing that money so much as breaking even.
Yeah, let me say a little more in defense of that, because a lot of people just recoil, because they think this seems like a cold sort of institutional feel, and they think it lacks that very human, personal touch that we all want from a caregiver. But remember, the things you do get is you get a professional who knows how to manage the money. Remember, these people, whoever you choose, is going to be managing your money. And that's a little scary for some of us thinking about our kids managing our money. And you have to decide, though, is it worth it in exchange for having somebody whose intentions might be good? And I'm assuming that you don't have the situation, Jill, you were just describing where somebody's deliberately reaching in and doing things.
Right.
But even if you assume the best of intentions with your children, is it not very, very conceivable that they make some bad decisions about managing the money? So the institutional option, you have professional money managers. You have lawyers involved, in this case in a good way, because they're going to assure that the I's are dotted and the T's are crossed. And believe it or not, they've actually, and I know, for example, in St. Louis Commerce, I know the people who run the trust division there, and you don't have to be rich. Now, some people may say if you have $1 million, you're rich, but I know a number of you out there, between your house and your other assets, you're over $1 million in total savings, 401k, et cetera. And for those people, I agree, 3% is high. So what I've heard recently, and don't hold me to this, but we were getting fees between 1% and 2% if you're above $1 million. So let's assume 2% on the low levels. But then if you're a little higher than that, like 3 or 4 million, probably a few of our listeners might meet that description. Then in that case, your fees are dropping to 1% or less. So again, don't hold me to Commerce's rates. But I do know that now there is competition to pick up people. You're more a person closer to the middle class who might have accumulated a significant amount of assets. And so you do get some personal service. I mean, these people will go out. They have people whose job on staff is to go out and shop for things and address very personal needs. So they'll come visit periodically. So I don't want you to think that this is just some institution in New York City that will send checks in the mail to your creditors. It's much more than that.
It's very personalized and tailored to a
Yes.
person's needs, it sounds like.
And one other important thing is you have deep pockets. So if your brother-in-law or whoever it is, your son-in-law may be more likely, makes some bad decisions and the money goes south and all of a sudden it's gone, I mean, the best you're going to get out of that situation is an apology. Because there's no recourse. This person likely doesn't have a lot of assets.
Otherwise, they wouldn't have done that.
They would have known how to manage better
Yeah.
if they had done better themselves. So the reality is that whoever's in charge of your money, whether it's intentional or unintentional, the money can disappear. And so you want to believe that there's some avenue for compensation. And that avenue for compensation with an institutional trustee is going to be by way of insurance and other assets. So that's another advantage. So it sounds like I'm really selling institutional trustees. I wouldn't be so supportive of that option for everybody. But I tend to support it for people who have significantly above, say, $1 million in total assets and who feel that they may not have a child or other close person to manage their assets for them.
And let's talk, this brings to mind to me, what about the people that decide to just put their adult child's name on the deed to their house? And that way it will transfer over to them when they pass on. But there can be some legal issues, legal debt that happen way before you pass away by doing that.
And to broaden the discussion, let's say put their name on any asset. So you mentioned a deed, but they could add their kids' names to bank accounts, stocks, etc. Missy, what is wrong with that?
Okay, so putting someone down as transfer on death on your bank account, meaning that when you die, they get the money, that is perfectly fine. That's the poor man's will you were talking about earlier. As a way of making things easier on themselves if something happens to them, sometimes clients will put a child's name literally on their bank account as a co-owner or on their house as a co-owner, and that leads to many, many problems. We would never recommend this. The better option is to get a power of attorney in place. But one of the reasons why we don't want to do this is because if they are a co-owner, they have legal rights to that property. Hopefully your children will never abuse that, but it happens all the time.
Oh, yeah, I'm sure.
On the flip side, it also is still their asset. So if they have debts, then the bank is going to be looking at your house like, oh, that's a nice chunk of money there. Let's settle that debt with that co-ownership there.
And divorce. Don't forget.
That's what I was going to say. If that child ends up going through a divorce, the spouse is entitled to that house.
We also have some problems with it's considered a gift. So if you put someone as co-owner on an asset that's going to appreciate in value, like a house or an investment account, there are some serious tax issues with that, and it's not to your advantage or your children's advantage to put them on as a co-owner.
Yeah, and it could be, I guess, gifting tax issues too. So, in other words, there's a long list of problems potentially with naming someone. And once you've done it, you can't undo it. You've made a transfer. So it's like if I were to add you, imagine that it's not a loved one. So Jill, if I were to add your name to a deed of a property that I own, just put your name on it. And let's say that I later decided that wasn't a good idea. It's gone. I mean, that half, that co-ownership, whenever I signed that, it became yours.
Right.
I lost the ability to unilaterally undo that. So now you're at the mercy of whoever you do that, who, remember, probably has a spouse. I'm real conscious of this as a former divorce lawyer.
Showing.
Yeah. And because it's often when you have problems in families like this relating to inheritance, relationships with other siblings, and estate issues and probate.
Yeah.
I mean, this may sound cynical, but it's often spouses that are stoking, some of these flames. I'll just say that. It's not always true, but it's often true. So once you've transferred that asset to a loved one, whether it's on a bank account or whatever, that is a completed act, a completed gift. So you need their cooperation to undo a gift. And with real estate, that means that you and that person needs to sign a new deed returning it to you. And in both cases, these were transfers of property. So whatever that involves in terms of local taxes and property taxes or transfer taxes in Florida, every time you transfer something, it's very expensive. Or it also has tax implications, as Missy just suggested, depending on the nature of the property, et cetera. This is worth noting, too, is if you add somebody's name to an account, it's not simply a transfer on death provision where it's just estate planning. But where you add somebody simply on an account,
they own it right then and there.
Yeah, and think about other implications of that. Let's assume that account earns money over the next year, which most accounts do, whether it's a bank account or securities. And guess who pays the other half of that tax? Who is responsible to the IRS? It's not you're responsible for half, and a loved one would be responsible. So depending on their tax bracket, you may have increased or decreased the taxes based on that transfer. But it was a real transfer. So now I will say this: there are some protective laws that have been enacted in a number of states, including Missouri, where they try to provide some protection for people who mistakenly do this. But the bottom line is you don't want to go there. You don't want to end up in a position where you've added somebody's name to an asset of yours on a title, whether it's a bank account, whether it's securities, whether it's real estate, whether it's a car, and then later be in the position where you're trying to make clear that you didn't really intend what the face of the title says. Face of the title in our example here indicates that you transferred half of it.
Yeah, that's just a disaster waiting to happen.
Yeah, and it's awful estate planning. Yet there are people who do it. Mm-hmm. You know, it looks like we're running out of time here. We try to finish on time, although we go over regularly, which is this nice new format. It's great for that purpose.
Yes.
But anyway, out of consideration for our listeners, we try to keep this at a length that they can listen to in a single setting. And we also did not get through some of the topics we wanted to talk about. So we can return to this. Because remember, we're talking about, what are the most common serious mistakes people make when it comes to estate planning, which also includes planning for the balance of your life here. I want that to be clear. We don't just talk about what happens to your stuff when you're gone, but we also want to give attention to your care and your prospering during the balance of your life, the last third of your life. So we should return to this topic.
Yes. Missy, coming back?
I would love to.
We'd love to have you back.
Missy, you're our authority on this topic, so we've got to have you back to complete our discussion here. This has been another episode of Elder Talk. Till next time, take care.
You've been listening to Elder Talk with TuckerAllen, providing intelligent answers for those thinking about their future, with Attorney-CPA Joe Cordell. Sponsored by TuckerAllen, your estate and elder law advisors. For more information, visit TuckerAllen.com. Listen again next Saturday for another edition of Elder Talk with TuckerAllen. The choice of a lawyer is an important decision and should not be based solely on advertisements.